ఈ పండుగ సమయంలో అందరూ గెలుస్తారు మలబార్ గోల్డ్ అండ్ డైమండ్స్ లో. గోల్డ్ లేదా డైమండ్ ఆభరణాల కొనుగోలుపై గోల్డ్ కాయిన్స్ ఖచ్చితంగా గెలుపొందండి. పైగా 10% అడ్వాన్స్ చెల్లించి గోల్డ్ రేట్ల పెరుగుదల నుంచి రక్షణ పొందండి. బంగారం ఎక్స్చేంజ్ మీద 0 డిడక్షన్ ఆనందంగా అందుకోండి. 10 దేశాల్లో 250 స్టోర్లలో బెస్ట్ డిజైన్లని బెస్ట్ ధరాల్లో పొంది గ్యారంటీడ్ గోల్డ్ విన్నర్ అవ్వండి కేవలం మలబార్ గోల్డ్ అండ్ డైమండ్స్ లో మాత్రమే. మలబార్ గోల్డ్ అండ్ డైమండ్స్, celebrate the beauty of life.
Boomy Instant Coffee is made with 100% pure coffee beans guaranteed. It tastes and smells like fresh brewed coffee without the weight. Our proprietary low-cycle extraction process maximizes the flavor and aroma, making each sip equally delicious. We're committed to serving you affordable 100% pure coffee with no additives or artificial flavors. Try a cup and join the millions worldwide who enjoy Boomy every day.
Hanumavega Courier Services, India to around the world.
Welcome to yet another exciting segment of Talk Show with the Experts on TVASIA Telugu. అమెరికాలో ఉండే ప్రవాస భారతీయులకి ఇమిగ్రేషన్ రిలేటెడ్ ఎన్నో ప్రశ్నలు తీరుస్తూ టీవీ ఏషియా మనకి ఎంతో దగ్గరైంది. This is an interactive and informative live show with our expert lawyer Rahul Reddy garu. He is one of the founders of Reddy Neumann law firm based out of Houston, Texas. Welcome to the show, Rahul garu.
Thank you for inviting, Andy. Thank you very much to be in the TVASIA Telugu channel.
Thank you so much, Andy. It's very interactive, very much informative all the time, knowing all this information from you. So actually the topic for today is really the visa bulletin for November is being delayed. It got released on October 26th. Why do you think there's so much of a delay around it?
In general, we are noticing from the past 6 to 7 months that it's been coming about 20th of the month. Previously, it used to come between 8th and 13th, but now it's been coming at 20th. Maybe it's a plan of the Trump administration, but the delay until now October 26th is a very unusual delay. It seems the delay occurred nothing to do with the visa numbers, particularly for Indians. It seemed to be that they wanted to delay it because there were some issues with Hong Kong. Should Hong Kong be part of China in the visa numbers, or should it be separately? That's the main reason why they delayed it until October 26th. Not much to do with the visa, with the Indian numbers. If you have noticed that the visa bulletin has not changed anything with regards to the filing chart. Right. It changed only by about 6 months for the EB1 category, that is for the final action dates, and about 21 days for the EB2 category, and about 2.5 months for the EB3 category. The final action dates have moved that much, but as far as the filing dates, they have not moved. Nothing has moved. The good part about is that the USCIS said they are going to go with the filing dates, not with the final action dates for the month of November. So awesome. All the rush people did it in October seems to be that, yeah, they could have filed in November too. What we have noticed, Sitagar, was that whenever the USCIS have taken the priority dates of filing dates in the month of October, as we have previously, Sitagar, to the audiences of ours, is that October is the new year for the immigration. So if they have taken the filing dates in October, they've also done the same thing in November most of the time. In sometimes they even extended that the filing dates all the way to December, and in 1 year they also extended all the way to January of that particular fiscal year. So right now, we are in good shape, so we should be doing very good. People can still file the applications in November. Maybe in December, we don't know, but for November, they can file the applications.
We are covered for November, and that's a very good news that you just shared. The dates haven't moved much, so as people were anticipating too much of back and forth in the dates, but that's a good news to know.
Sure.
Yep. We have a lot of callers. We have a lot of YouTube questions. So let's take the first caller in. The caller ends with 2839. Please unmute yourself with *6. Before that, let's take the first question on YouTube here, Andy. It is from Kumar Reddy.
Yes.
Hi, Rahul. Sorry?
Go ahead, Chidaka.
Hi, Rahul Reddy Garu. Thanks for your great support. So my EB2 priority date is June 6, 2011. Can we expect filing date movement for at least a month in December EB2 bulletin?
What we noticed is that the filing dates do not move that much, though. In a given year, normally when they have advanced the filing dates in October, we haven't noticed the filing dates advancing as the months progress. And also, even if the filing dates progress in rare circumstances, when they do, though, do not expect that the immigration is going to accept the filing dates all the time. Out of the 60 months, they only accepted about 13 to 14 months they did accepted the filing dates for the employment base. Rest, everything, they accepted the final action dates. So, if you haven't filed an application under the downgrade application, you may have to wait for one more year for your priority date to become current in the filing chart.
Right. Okay. I guess we have the caller here. Can you press *6 again and ask your question? Yes. You again are on *6. Can you press *6 again? You muted yourself now. Please unmute and go ahead with your question. Yep.
Hello. Good afternoon, Rahul Reddy Garu. This is Kumar Reddy.
Yes, Kumar.
Thanks a lot for helping out the community, sir. I have a question regarding the forward movement of EB2I. I think I got the answer now. I am just 23 days behind that. My priority date is June 6th. So I was just keeping hopes that it might go forward. Just want to check with you the possibilities.
Well, you got the answer, Kumar, before, so you may have to wait for next year.
Yeah. Okay. Thank you, sir.
Okay.
I appreciate it.
Thank you, Kumar, for coming and joining us.
Thank you so much. Let's take the next caller here. The caller ends with 0897. Please be ready with your question. We will get to you in a minute. Rahul Garu, the next question here I'm seeing is from Kumar Bathala. Please share your insights on the effect of USCIS processing times given the huge volume of I-485 and I-40 downgrade applications. Can this lead to wastage of the spillover family-based EP green cards?
What we noticed was that the USCIS might be leaning towards no interview at all. We noticed in the past, especially 15 to 30 days, they've issued an RFPs for the medicals. That means that they may just take the medicals and adjudicate the applications without any interview process at all. Okay. The interview process was introduced in 2017. Since then, we have noticed that the 485 application delay has been occurring significantly. Since the COVID has come in, the USCIS in some circumstances have waived the interview process. Seems to be that they may be doing it very much. The reason I am pointing out RFP and the medical is that they're not supposed to issue an RFP and medical. They're just supposed to tell us, hey, bring the medicals to the interview. The reason what I'm suspecting they're issuing RFP and medicals is, hey, we don't want you to come for the interview. We'll take your medicals and we'll just approve the case. Right. There's a good possibility that because of approving without interview, they may speed up the process of the adjustment of status. One thing I have to point out that if the I-140 has not been approved, they cannot, I mean, if you're downgrading from EB2 to EB3 and you file the 485 application, they cannot approve the 485 application until the I-140 has been approved. Once you get the receipt notice of the I-140, we strongly recommend that you do premium processing of the I-140 to expedite your 485 application.
Right. I think that answers their question. So we have the caller here. Can you press *6 to unmute yourself and ask your question?
Hello.
Yes, sir.
Yep.
Yes, go ahead.
Sir, very good afternoon, sir. Sir, actually, we have applied for LCA for September 26th, which I have extension for 2 months actually. So then that is got approved. So now after my firm approval, if I what happened, if you want to go, can I use the same LCA for the 7th year extension, sir? Because already September 26th they have done. So recently the policy got changed, right? So
right.
if I go with next extension,
I don't see any reason why you cannot. Yes, you can use the same LCA to file an extension. You may be limited by about 2 to 3 months in getting up to 3 years of H1B, but I don't see any problem in you using the same LCA for filing the H1B extension once your permanent I-140 is approved.
Okay. So why? Because that LCA is valid till 2023, sir. Actually.
I got the point. You should be able to use it.
Yeah. Okay.
Yes.
Okay. Thank you, sir. Thanks a lot.
Thank you very much.
Yeah. Thanks for your time, sir. Thanks a lot. Okay.
Thank you.
Thank you so much, Andy. Please do watch TV Asia on all the various platforms that we are available as well on Facebook, YouTube, Twitter, as well as on World BB TV. Thank you. Here is the next caller. It is 7912. Please be ready with your question while we take the next question here. It is from Sagar Srivastava. Priority date is April 2012 on EB3. He's a BE Electronics and Communications background. What are the chances that they will deny my I-485 filed this October due to the I-140 specialty occupation, H1B issue of degree mismatch?
First is he's discussing about 485 application because of the electrical engineering degree though.
Correct.
His I-140 is already approved. And he's not even filing a downgrade application from, applications from EB2 to EB3. So we are not expecting anything at all on your degree issue because no I-140 has been filed. Your H1B has, at this point of time, is not relevant at this point of time. Why the H1B has been approved, why the H1B is not that much relevant at all, unless you have used some fake documents, in which case your 485 should be denied anyway, which I don't see. You are that kind of person. So I'm not expecting much problem for your 485 application because your I-140 is already done. Your H1B is already, your H1B will not be considered for the 485 application. It's just whether or not you have committed any crimes. Do you still have the job offer? Those are the things that are considered. I'm not expecting much problem for your 485 or adjustment of status application.
Awesome. Yeah, we have the caller here. It is 5875.
Yeah, hi. Rahul V, are you able to hear me?
Yes, sir.
Okay, hi. My name is Rahul V. So I have 2 questions on it. So one question is, my company got acquired by another company. So we filed 485 last week actually. So my priority date is 2013 EB3. Now the question is, will it delay any of my process? Is it the same process, same as downgrading? That is first question.
It would be, you might have filed an I-140, right?
Okay, hi. My name is Rahul V. So I have
Shashikant, can you mute your TV?
My company got acquired by another company.
Shashikant, can you mute your TV?
I don't have TV only.
TV.
No, I don't have TV. It is 2013 EB3. Now the question is, will it delay any of my process? Is it the same process, same as downgrade? That is
iPad somewhere.
No. I mean, I'm in a car garage basically. I came to car garage.
Give us 1 second. Let's figure out what's going on. Yeah, go ahead. Go ahead with the question. I'm sorry.
So that's
Shashikant.
So okay, so my company got acquired by another company, and that is.
But did you file? Did you file an I-140 right now, or only 485?
485 with amendment. That's what they said, and 140 amendment
Right.
they said actually matter.
It is very similar to. It is very similar. The process is very similar to that of. The process is very similar to that of downgrading. Nothing different for you.
Okay, so will that impact any of our process? I mean, will that impact any of our 140s or approvals or anything?
No, it should not impact any I-140 process because it is very. I mean, it is very similar as I described with you as a downgrade process. Nothing different. Okay, so you should be able.
Will it delay any of our process?
If the premium, you can do premium processing to avoid all the problems.
Okay. Okay. So second question is, sir, my wife, she is completing her 6 years next H1 next year, June and actually. So is it good to go for H4 EAD or wait for this EAD?
I would do both. I mean, you might have already filed an EAD. If not, you could always file an EAD under this 485 application.
Yes, we already filed.
I would do both though, because you don't know which one will come faster. I would do both.
Okay. Okay. So, ఈ timelines ఇప్పుడు downgrading కి risk ఏదైతే మీరు చెప్తున్నారో మాకు కూడా అదే risk ఉంటుందండి.
As I said, you have this very similar risks of what you have for the downgrade. Nothing different. There is a good chance that they will accept your premium processing and adjudicate your I-140 sooner. Very good chance. There is some slight chance that they may not accept the premium processing. That doesn't mean that it's going to be denied. It's just the premium processing they may not accept. Sometimes they don't. But recently though, but we have noticed it, they're accepting premium processing even if you're filing for an amendment and downgrade.
So how much approximately మీరు ఇప్పుడు కాకపోతే last 2 years లో 3 years లో approximately
you know the timing, you know the time processing for the I-140s, right? You have the premium processing. Once that is approved, you are just Tom, Dick and Harry. There is no difference for you and anybody else.
Okay. Okay. I think, yeah. And that's it from my side. Thank you.
The reason why we suggested a lot of people not to file in a premium processing when you're filing the downgrade application is because the USCIS does not have a proper procedure in filing downgrading and 485 at the same time. But right now, you can convert into premium processing once you get an I-140 receipt notice.
Okay. Okay.
Thank you so much.
Okay, and I think definitely.
Thank you.
Sorry for the very technical glitch in the start.
No problem. Next, let's go to the questions.
It is 4108. And before we take the caller, here's a question from 𝗟𝗡𝗙𝗪. The question is, hey, my priority date is July 2009. When can I start filing? I'm in the F3 category.
Oh, F3 category. What did you say his filing date is July what?
July 2009.
Right now, it's June 2009 for the F3 category. So let me check. Is it November visa bulletin? Yeah. So he's about 1.5 months backward with regards to but the dates, don't move every month, 1 month though. It may take 1 year, it may take 2 or 3 months. I can't tell it right now. But it's right now for F3 category, it's June 2009. And he's saying that he's July 2009. So that's about a 1.5 month waiting period.
Okay. So wish you good luck. So let's take the caller. It ends with, the caller ends with 9712. Please press *6 to unmute yourself and go ahead with the question. Yep.
Yes, go ahead, sir.
We can hear you.
You press *6.
Oh, yeah.
Yeah, go ahead, sir.
Thanks for taking my call. I have two questions, sir.
Mm-hmm.
So I was currently, I was with employer A and then I was working for a different client and that was ended in August. And now I'm working for a different client with employer B and then my H1 is approved. But during the month of September, I don't have a payroll or I did not work for any client. So how would this be affecting me in future for that 30 days?
How is it only 30? So you moved from one employer to another employer right now, is that right?
Yes, yes.
You are allowed to have a 60-day grace period between one employer and another employer, and you're telling that it's only 30 days, so you're good. I don't see any problem for you.
Okay, so the 60 days is like for overall six years period, or like
no,
between
it's
like
between each employer. So if you move to A to B, that's 60 days. From B to C, then it's 60 days. As long as you're keeping on getting the H-1B approvals, you have that 60 day for each switching of the employers.
So this will not be anything like I'll not be having any issues like during any visa stamping or anything like that.
No, sir. I'm not expecting because of this. I'm not expecting much problem because of your 30-day gap period right now.
Oh, okay.
Okay.
Thank you, sir.
Thank you very much for tuning in.
Well, thank you so much. Let's take the next caller, 4108. Once the caller is admitted and we take the question, and let's move through the YouTube question here. It is from 𝗧𝗔𝗟𝗪. I'm on H-1B and approved I-140 in 2016. I got a Canadian PR and want to move to Canada and then come back to the US in 2024. If my priority date becomes current in 2021, will I lose priority date and when I come to US?
Assuming if the priority date is not current in the final action date, though, he can definitely move to Canada and he can come back in 2024. He can retain the priority date by filing another labor and I-140 application. We see that a lot of times people who have went back to India, they come back after 7 or 8 years and we put their dates into current application. Not a problem at all.
Okay. Okay. That answers it. Let's take the caller's question. Please go ahead with your question. We can hear you, sir. 4108 is the caller ending with 4108.
Yeah, hello. Yeah, hello. Can you hear me, Rahul Garu?
Yes, we can.
Okay. Yeah, so my EB2 priority date is March 10th, 2010, and I have filed my I-485 using date of filing last month. So if EB3 final action, thank you. If EB3 final action dates become current before EB2, and I file a downgrade I-140 for EB3, should I file I-485 again for EB3 or ask USCIS to link the...
I would recommend that you file the 485 again, though. What they will say is that this application was not, the I-140 was not there at the time when you file the 485 application, so they may deny your downgrade, they may deny if we try to link it out. The better approach is filing a 485 application again. Having said though, I mean, I'll be very reluctant of you're in adjustment of status, you're in a path right now. I'd be very reluctant in downgrading and filing an EB3 application for you. It's nothing illegal. It's nothing illegal. It's just my opinion, okay? It's nothing illegal if you do it. Downgrade and file an adjustment is nothing illegal. But I wouldn't recommend that you do it.
So when I asked my lawyer, she said we can just file the I-140 downgrade and link the existing 485 to EB3 I-140.
We tried that many times. A lot of times problem occurs with that application though. A lot of times. So it is not that what your lawyer is suggesting is illegal. It's just practically the immigration doesn't have a proper system to link the 485 application with the new I-140 application.
Okay, so basically you're saying just go ahead and file the 485 again so that you can have both parallelly going on.
That's right. That'll be safer method.
Will that lead to any problems because of having two I-485s in progress at the same time?
No, it will not lead to any problems.
Okay, so it's just that I have to pay the I-485 fees again.
Right. You can even try what your lawyer has said to see if that works out. We have seen some cases it works out, but my method is to refile the entire application. That'll be much easier.
Okay, but so like you said, in the downgrade, there is one risk of I-140 getting denied. So if we ask them to link to the existing I-485, that means I'm giving up my EB to I-485.
No,
right?
You're not giving up. You're not. If you're filing one, are you filing one more 485 or you're not filing one more 485?
No, I'm not filing for. If they ask to link it, then I'm giving pretty much.
You won't link it until your I-140 is approved. If you're going with this advice of not filing a 485, you will not link it until your I-140 is approved. You will wait until I-140 is approved, then link it.
Oh, okay. Okay,
You got it?
But
Okay,
yeah, got it. That means that yeah. Okay, got it. And
you'll be safe.
in the downgrade, so this specialty occupation thing that came up recently, which is going to be effective in December, is it going to be for I-140 processing as well, or is it just for H-1B?
Just for H-1B.
The reason I'm asking is I have a mechanical engineering degree and I'm working in software. That's the reason I'm asking. Will that lead to any problems with EB3?
That the specialty occupation H-1B is not applicable to the I-140. However, though, the adjudicators may look a little bit more deeper when you're filing an I-140 downgrade application to see if they would like to. There is a chance that your I-140 may be denied. Even though it was approved previously, there is a chance that they may deny it right now, irrespective of what the new law says. Because the new law is not applicable for I-140, but there is still a chance that your I-140 for the downgrade might be denied.
Okay, so that will not, but still that will not affect my I-485.
I would, in your case, I would suggest that you do not downgrade, do not do anything. Just let it flow right now as it is, because you have a mechanical engineering degree.
Yeah, I'm not downgrading right now, but if my priority date becomes current
when the priority date becomes current, I still will not downgrade for you if I were your lawyer.
Why not? Okay. Why not take a chance? And even if it gets denied, my EB2 will still be alive.
There is a chance they may intend to revoke for the other I-140 also. There is a chance for it. I would not like to take that. It's up to you. That's what my advice would be. We'll go to the next caller. It's up to you. This is my advice. Okay. You think so, you want to take a risk, that's up to you and your lawyer. But if you're my client though, I would say no, I would not file up your application.
Okay, got it. Thank you. Thank you very much for your time.
Thanks, Rahul, for those valuable advices. So
sure,
you would ask the callers to take a judicious call. This is the advices that you're providing. So we have onboarded the next caller here. And before we take the caller's question, let's see the YouTube question here. It's from Ramya MP. USCIS sent us a notice to submit AR11 form for my spouse H4 EAD application, as receipt notice was undelivered to our address. He's not in the US right now. Can we still submit the form?
Yes. Yes, they can still submit the AR11 even though your husband is not in the country. His address is still the address where you're living in. No problem in submitting the AR11.
Let's take the next caller, 5003. Please ask the question. I hear some noise, sir. There's a background noise. Can you please mute your YouTube? Yeah, please ask your question. Go ahead with your question. We can hear you. Caller ending with 5003.
Well, he doesn't want to ask a question.
You have muted yourself again. Please press *6 to unmute yourself and ask your question. Rahul garu, inko question తీసుకుందాం ఇక్కడ. Caller is, the YouTube person is Ravi Kumar Burila. He says, my wife H1B approved cap with I-797A and got I-94 valid until 2023 while she's out of the country. She returned to US on H4 as US consulates are closed, and she started working on H1 as she got I-797A and I-94.
No, she cannot, because the I-94, recent I-94 that she got is for the H4 visa. She had to file a change of status application from H4 to H1. That's number one. Number two, the change of status application that was approved for H1B is wrongly approved. She shouldn't have got the 797A. She should have got a 797 without an I-94. Just because the immigration does a mistake, you cannot cash on it. I want this lady to apply for a change of status application from H4 to H1, and after the H1 is approved, she should start working.
Okay, perfect. Okay, let's take the caller. I hope you have unmuted yourself, sir. 5003. Please go ahead with your question.
Yeah. Hi, Siddhar. Can you hear me?
Yeah, we can.
Yes.
Hi, Rahul V. Thank you, Andy. Recently, I moved to new employer, in September 2020, and my H1B was approved.
Mm-hmm.
With my previous employer, my H1B was approved in the month of August 2020. If I wanted to go back to previous employer, can I go?
Did you ever travel outside the country after you moved to the new company?
No.
Did your previous company withdrew the H1B after you moved to company B?
No.
You can go back. Absolutely no problem. They don't have to file anything. You can go back to the previous company, sir.
But my previous employer is fine, but previous employer attorney was saying that since it is last action rule, so I have to do H1B transfer if I want to move back to previous employer.
Last action rule is applicable when you're applying for a change of status application from company from H1 to H4. Last action rule is not applicable if you move from company A to company B, which is both H1Bs, is that right? The company B also got a H1B, not a L1 approval. So that last action rule is not applicable to you.
Got it. Thank you. The other question is, if I want to file my I-485, it is not my priority is not current at the moment, but in next 1 year, 1.5 years, if it is current, and if I want to apply for 485, do I need to go for stamping because I do have 2 active I-94s?
No, you don't have to. Your I-94, look into the I-94 number of both company A and company B. Both of the number will be the same. It will not be different. It will not be different. You don't have to go outside the country. You can mention in the 485 application for this 6 months period or whatever period that you're working with company B, you can mention it. Absolutely no problem with it.
Got it, sir. The last question. I see there is an error in my form application form 9089. So I worked with one of the company from 2013 to 2014, but in form 9089, it was typed as 2003 to 2014. Instead of 13, they typed as 2003. Will it create any problem?
Let me ask you the other question though. What about any other employment that you listed out?
Other than that, yes.
Okay. Sometimes I have to look into the labor certification to determine if that mistake is a material mistake that would have had your labor certification denied had you put 2013 to 2014. But if it's not a material mistake though, I would progress that I would file an I-140 with that labor certification, proceed, and explain to the immigration officer saying that, look, it was a clerical error that wouldn't have made any difference whatsoever at all in getting the labor certification approval. That's what I would do. But I have to look into the labor certification carefully to see if that is a material error.
Approved with that. Sorry.
Okay. Yeah. I-140 is approved. Yeah, I still have to look into the labor certification to determine whether it's a material error or not.
Got it, sir.
Thank you so much.
Thank you so much.
I would have filed your 485. If it is not a material error, I would have filed your 485.
Got it, sir. Thank you so much.
Thank you. Thank you.
Thank you so much, Ram Garu. So patiently you've been taking all the questions. Appreciate all that you're doing. We have the next caller here admitted, and let's get into the YouTube question here before we take the caller's question. Sure. It's from 𝗬𝗪𝗡 𝗪𝗡𝗥𝗧𝗦. My last name is spelled incorrectly on I-140, but it is very hard to notice due to the fact that it is very long. Only 2 alphabets swapped. I have filed I-485 with it, or what could be the consequences?
I'm not expecting any problem. It's just a clerical error though. And it's very clearly we can determine it's you who is that person. Not only that, you're going to go to biometrics and they're going to take your biometrics and match the things if you are the same person or not. I'll be very surprised anything bad can happen for you because of the I-140 error.
Okay.
in the name.
Okay, that's good luck. Kamleshwar Garu, that's some good news for you. Let's take the next caller here. And let's see who the caller is. The caller ends with 1084 is what I'm seeing here. Please go ahead.
Hey, hi, Rahul.
Yes, ma'am.
Yeah, thank you for taking it. Actually, I got my question, a part of my question answered to the YouTube comment, and I have a follow-up question like it's regarding the AR11 form. So the receipt notice from USCIS was undelivered to my address because like my husband's name was not on the mailbox, like he's not on the leave yet by when the notice was sent to us. But like I have talked to my leasing office and made some arrangements to make sure I get any communication on behalf of his name. So can I submit this AR11 form with the same address where I'm currently living in?
You can submit it. You can submit it. You can submit it with the same address. I would do one thing. I would go and buy like about 20 or 30 stamps, and I will keep mailing every single day a mail to your husband's name to make sure that it's getting delivered for you.
Okay.
You see my point? I don't want to rely on statements given by you, the leasing office, the post office. I would keep on dropping the postcards every single day on your husband's name so that things are rectified and then they've been done properly.
Okay. Just one more question. Like, if there is any problem with this address thing, like, can I use any of my relatives' address or friends' address, like, as an alternative address? Where, I would rather,
in the AR11, you're supposed to disclose your current address, not your relative's address, though. I would follow the path what I explained to you to better rectify it rather than use a relative thing and then try to, end up in the same soup where you came from.
Okay. Yeah.
Okay.
Thank you. Yeah,
thank
that's
you.
all I have. Yeah. Thank you. Yeah.
That's a very good advice you've given, Andy. It actually is reassuring that the things are in the right place for ourselves.
Yeah.
Yeah. So let's take the next caller here. The caller ends with 9080. And before we get the caller's question, let's have a YouTube question. I see it from a YouTuber here. We are on EB2 EAD or advanced AP with priority date of Feb 2010. Since our dates are current for FA in EB3 category, what is the procedure? Do we need to find EB3 I-140?
So his priority date is current under EB2, but the EB3 is current. I wouldn't do anything. I wouldn't do anything for you though right now. I wouldn't file the downgrade application and try to mess around with the existing application. Your application has been pending from 2012 to right now. Don't do anything. Wait for the EB2 date to get current, and once it gets current, contact the USCIS to adjudicate your application.
Awesome. Okay, that's nice. Thank you so much, Andy. I think we can take the caller's question. Please go ahead with your question. Caller ending with 9080.
Hi, my name is Sandeep. The question I had is, Trump stands for meritorious immigration, right? I mean, at least that's what he's been saying. And so why do you think, and also this opening which happened is because of stopping family immigration, right? So why would you think that, Trump is not good for immigration or Biden is better? Like, what are your thoughts on this?
I'm not going to, as an individual, I have a private opinion on Trump, which I don't want to disclose it to you. But as far as the immigration is concerned, though, Trump has very clearly explained to us that he doesn't want any immigration whatsoever at all. His administration has unveiled a plan right now, which they did not disclose it. They're saying it's so radical that they even want to attack the birthright citizenship. That's one of the main things that you need to look into. It's just not the business immigration. If you look into the restrictions that he have imposed on the H-1B in the past 6 months, that humongous of restrictions, it's not that he wanted to do a favor to us by banning the family immigration. It is that the law said it, that he has to give this he has to give this excess green cards, that he banned it through the family immigration, it came to us. If he were been given an authority, he would not have given the employment-based immigration to us. I mean, he wouldn't have given the excess green cards that were not used by the family immigration. He wouldn't have given to us. That's my opinion. And I'm not telling that, somebody else might not have a different opinion. But don't expect that if Biden comes in tomorrow, he's going to change all the laws and make it very good for the employment base. Do not expect that. I have seen that. When Obama came in, we were having a high hope because he was having a favorable as compared to John McCain. Obama had a very favorable thing on the immigration, but when he came in, he didn't do that much good job though. We called Obama as a deportation king. So there are some pluses in the Trump administration. I wouldn't say that everything Trump does is bad. There are some pluses, there are some minuses, and Biden also has some pluses and some minuses. So each individual has to evaluate themselves, who is better.
Okay, thank you, sir, for your perspective. And I just want to sneak in one little question here. If people are getting these EAD cards now, there's a frenzy, everyone is applying till 2015. Do you really think if you get an EAD card, you're kind of safe and one day or the other, you will definitely get your green card?
Good question. Very good question. One thing is that assuming if the underlying I-140 is approved, okay? Now let me tell you the stats that I know about. Less than 2% of the people ever get into trouble once the I-140 is approved, 6 months passes through, and EAD comes through. Less than 2% of the people ever get into trouble. That's the stats.
Thank you, sir. Thanks for your clarification.
Thank you.
Thank you so much. Rahul, let's take a very short break before we take the next caller and the questions.
ఈ పండుగ సమయంలో అందరూ గెలుస్తారు మలబార్ గోల్డ్ అండ్ డైమండ్స్ లో. గోల్డ్ లేదా డైమండ్ ఆభరణాల కొనుగోలుపై గోల్డ్ కాయిన్స్ ఖచ్చితంగా గెలుపొందండి. పైగా 10% అడ్వాన్స్ చెల్లించి గోల్డ్ రేట్ల పెరుగుదల నుంచి రక్షణ పొందండి. బంగారం ఎక్స్చేంజ్ మీద 0 రిడక్షన్ ఆనందంగా అందుకోండి. 10 దేశాల్లో 250 స్టోర్లలో బెస్ట్ డిజైన్లని బెస్ట్ ధరాల్లో పొంది గ్యారంటీడ్ గోల్డ్ విన్నర్ అవ్వండి కేవలం మలబార్ గోల్డ్ అండ్ డైమండ్స్ లో మాత్రమే. మలబార్ గోల్డ్ అండ్ డైమండ్స్. Celebrate the beauty of life. ఈ పండుగ సమయంలో
రండి చెప్పేస్తే ఏం బాగుంటుంది. ఆ బీట్ స్టార్ట్ కాగానే మీకే అర్థమైపోతుంది. ఆస్వాదిద్దామా?
Oh my God, Daddy, just don't be my daddy. Changu bala illaga nenu ela maripoye changu mani balega maate mantramo manase bandamo.
చూసారు కదా, మీరు కూడా అలాగే పాటలు పాడి అందరికి వినిపించాలనుకుంటే సింగ్ అ సాంగ్ @TVASIATELUGU.com కి మీ వివరాలు పంపించండి.
ఈ పండుగ సమయంలో అందరూ గెలుస్తారు మలబార్ గోల్డ్ అండ్ డైమండ్స్ లో. గోల్డ్ లేదా డైమండ్ ఆభరణాల కొనుగోలుపై గోల్డ్ కాయిన్స్ ఖచ్చితంగా గెలుపొందండి. పైగా 10% అడ్వాన్స్ చెల్లించి గోల్డ్ రేట్ల పెరుగుదల నుంచి రక్షణ పొందండి. బంగారం ఎక్స్చేంజ్ మీద 0 రిడక్షన్ ఆనందంగా అందుకోండి. 10 దేశాల్లో 250 స్టోర్లలో బెస్ట్ డిజైన్లని బెస్ట్ ధరాల్లో పొంది గ్యారంటీడ్ గోల్డ్ విన్నర్ అవ్వండి కేవలం మలబార్ గోల్డ్ అండ్ డైమండ్స్ లో మాత్రమే. మలబార్ గోల్డ్ అండ్ డైమండ్స్. Celebrate the beauty of life.
Welcome back, and let's take the next callers here, Rahul Garu. There are people anxiously waiting on calls and on YouTube questions.
Sure.
The next caller is 05. I think I missed it. Yep. It is 0564. Before we take the caller's question, let's have a YouTube question here from, I see the ID here is Orange3612. The question here is, I'm on EB1 with priority date of October 19, applied on 485 last month. Can you please tell me what happens to EAD and AP application in case my priority date becomes current in next couple of months?
If the priority date becomes current, your EAD will still be adjudicated. It will still be approved. If your priority date backlogs also, EAD and EP will still be adjudicated. Will not have any problem in that, EAD and EP.
Okay. Let's take the caller's question. Yes, sir.
Go ahead, sir.
Hello?
Yes, go ahead.
Hi, my name is Raghu Andi. I have an EB2 priority date of September 30, 2010. So my company, after filing my H1, what they did was they created a sister company in 2013. So started from 2013, they moved all our H1s to that new company. And I'm still with that sister company. And recently, last month, I think 10 days ago, as the dates were current, they filed my 485.
Did they file an I-140? Did they file an I-140 amendment?
No, so they still running that old company also.
Oh, okay. Got it.
So what they are saying, it is like a future employment, but it's their company. They will support every employee. So both companies are running. But the only thing is my current H1 is with the new company. And then there are many employees like that.
Yeah, technically it's not a problem that the company is, it's a future employment. It's technically not a problem. However, though, there's one problem that I have. If there are a lot of employees that they are filing adjustment of status with this previous company, my major question that pops up is that, is this company still operational? How many employees do they have right now? Yeah, at the time when they filed it in 2013, they may have 100 employees. How many employees do they have? Does their financial support your application along with all other people who are filing with 485? If the question raises that the company doesn't have the sufficient funds, then the whole thing might fall down. I would have filed an I-140, I would have filed if the company would have been eligible, I would have filed an I-140 approval amendment. If the new company is not eligible for it, I would have filed another labor and I-140 application. But I have to look into you have to have a lawyer evaluate independently based on the financials of the company, if the company is sufficient enough to support the 485 applications that they are filing. Because if you're working for the company, you're already getting paid. It's not a big deal that financially they are capable or not. But if you're not working for the company, and like that 20 people are there, you're speaking about $2 million profit they have to show every year, which I doubt because it's not an active company.
Right. So so unfortunately they moved, like we did not leave the employer, but they created a sister company because I think they had too many employees in the first company.
As I said, I have to look into, you have to show this financials of the company to evaluate. Otherwise, you may have to file an amendment, or if needed, if the amendment, you're not eligible for amendment, if needed, maybe file another labor certification, sir, to be on the safer side. Okay? Thank you for
one last question.
Go ahead.
Sorry. So if as they filed my 485 already, are we eligible to move employers using the 485J if my current client accepts me?
Good question. You still will have some risk of, if they reopen the entire people, like if they filed the 2485 application, you may still have some risks associated with getting your 485 approved. Because your 485 must have been approvable at the time of filing the application. They may say that it's not approvable. So that question might arise So I would be a little bit careful with you as compared to the rest of the people. Okay?
Thank you, sir.
Thank you very much. Thank you.
Thank you so much. Please watch and subscribe TVASIA Telugu. Here we have expert advice from Rahul V. He's such an eminent lawyer. And you can watch TVASIA on BBTV stream on network.
The caller, you have to mute your TV, sir.
We have the next caller onboarded, 2632. Please go on mute. We have, let's take a next question here, Andy, before the caller's question.
Sure.
From Murli R. In downgrade application, what will be mentioned in the wages for I-140 application? Amendment for I-140. Following to above are these wages anyway related to increased new wages?
The wages will be based on the labor certification that was approved before 2015. There will not be any new wage report or anything required. You're just using the same labor certification, so no new wages report is required right now. It's an old labor certification that was approved before 2015.
Perfect. We have the caller 2632. Please ask your question. Press star. 2632. Oh, okay, we lost the caller, looks like.
Sure.
Yep. Let's take the next caller here, 95950. And we can take the YouTube question before we have the next caller here. It is from Deep's important emails. Okay, the question here is, can I go to US-Mexico border location and get automatic visa revalidation done, or should only fly to some Mexico city from USA?
Automatic, assuming that you're eligible for automatic revalidation, you right now, because of the COVID, there are some restrictions with regards to the land travel. That means that when you travel to Mexico or when you travel to Canada, coming back through the land, there are some restrictions that are there. That's the reason we do not recommend you take the land travel. I would rather want you to fly to Mexico and fly back from Mexico to here so that you don't be stopped at the land border because of the COVID restrictions. Those COVID restrictions are not there if you fly in.
Okay. Okay. That's good to know. We have the caller here, Andy. Please unmute yourself and go ahead with your question. Caller ending with point.
Hello.
Yes, sir. We can.
Yeah, thanks, Rahul, and thanks, Sita, for taking the calls.
Thank you.
Yeah, so I have a question, sir. My PIT date was 2015 September. Is an EB2. I'm planning to downgrade to the EB3, but I'm in a typical different situation because my wife, this is for my wife case actually. She got a maternity leave, and I filed recently on the September, I recently filed a change of status to her. So H1 to H4. So the H4 case is now pending. Yeah.
H4 case
so
is
the
still pending,
H1 case now is pending. Yeah, that's still pending. I didn't receive the fingerprints or anything. The case is still pending. And what can I do? Can I file now change of like EB2 to EB3 downgrade, and I can file 485?
Right now, the prior date is not current for her, is it right? So there's no 485.
2014 September. Sorry, if I mentioned wrong, 2014 September.
Okay.
Yeah, sorry for that one. Yeah, sorry.
Yeah, it's not you or your wife who's going to file the I-140 application. It has to be your wife's employer. Your wife's employer, if they are ready to do it, if the finances of the company are sufficient enough though, because she's not working with them anymore. Yes, you can file an I-140 application. Yes, she can file a 485 application along with this I-140 application.
Okay,
but the finances, even though she has moved to H4 and she's not working for the company, the previous company can still file an I-140 downgrade application, and they can still file a 485 application if the finances of the company are good. That is the caveat.
Okay. So I mean, that is only one scenario. There is no other, like I can go, because my attorney is saying, like, even if the change of status I'm doing, so they're asking me to withdraw the change of status and then I can able to file that one. But that seems not correct to me. That is the reason I want to make a confirmation.
It is. I wouldn't say that what your lawyer is telling wrong. Here are the things, though. These are the rules. What I'm speaking. But the company may want to impose extra rules that they want to. That's up to them. That is their policies.
Okay.
So the company may want to the company may want to remember that I told you finances are an issue. So if your wife starts working for the company, finances may not become much issue. So they're trying to play in a defensive role there to make sure this I-140 is approved. So I'm not telling that lawyer is wrong. I am right. I'm not telling that. You can do it.
Yeah, I got it.
You can do it, but that lawyer can impose extra restrictions if he wants to, based on the finances of the company.
Okay.
Okay.
Yeah,
thank you
because
for tuning in.
I'm with the thank you, sir. Thank you for your clarification.
Thank you so much.
Thank you.
Thank you so much. And we have the next caller here, 4801. Let's admit the caller here. And Rahul Garu, I have a question from Rockstar here. Looks like he has about 3 questions. We'll try to bundle it here and say the first question here is, my package delivered around 8:30 p.m. on Friday to the lockbox facility. Will the USCIS accept that or not if end date was on October 31st? That is the first.
Right now, the priority date is current in November also. It doesn't matter whether it's received on Friday or Saturday or Monday or Tuesday. Even if it's received this Monday, they're going to accept it because it's still, priority date is still current.
Okay. I think the next question falls, you have already answered. The question is, if the end date falls into weekend, will they accept the packages on the next business day as well?
Right. Right now, right now they do, because until November you're current, so you shouldn't have a much problem.
Awesome. Let's take the caller's question before we take the next YouTube question here. Please go ahead with your question, Andy.
Hi, Rahul and Sita. Thank you for giving this opportunity. Sure. Can you hear me?
Yes, sir.
Yes, we can.
Yeah. Regarding affidavits from the parents, my question, my passport has place of birth as a Krishna district, not the village name. My passport has a district name as a place of birth. So in affidavit, I will mention my village name, district name, and state and country. Is it okay?
Perfectly fine.
Perfectly fine. Because if visa officer, if they verify why this village name is not there on the passport, will it be a problem or?
No.
Anyway, Krishna is also already covering in. Okay.
Yeah. All these officers, they have access to a thing called Google. They do search in the Google what Krishna district means.
Okay. Thank you, sir. Thank you so much.
Thank you.
Let's take the next caller here, 3550. And before they admit the caller here, question Andy from same Rockstar. He has a last question here, which says, in case if the kids are aging out next year and priority date still not current in final action chart, what are the options? Should they move to F1 or should they continue on 485?
They should move to an F1 visa. That's number one. And they shouldn't wait until they become 21. I would start the process when they're 18 or 19 and then move them to F1 visa. And if the priority date, final action date becomes current, then you can just, take the F1, roll it as a football and kick it out. They don't have to worry about the F1. But I want to be on a defense side. I don't know how the dates will move. I want these people to get the F1 visa.
Right. A safer approach that way.
Yeah.
Let's take the next caller here. Yes, sir, we can. I think it is 4801. We just had the caller 4801. Please press *6 to unmute yourself and please ask your question.
Yes, sir.
Hello.
Yes, sir.
Yes, go ahead with your question.
Hi, Rahul Garu. Good afternoon. I have a question. I recently got a 100% remote position in my current petition MSA. So in this context, do I need to go for an amendment if my job title, duties and salaries remain everything same?
Did you said that the position and your house is in the same MSA?
Yes, you are right.
You do not need an amendment, sir.
Okay, so even though my new client headquarters is located in other MSA, still I don't require an amendment in my case.
When they filed the H-1B, did they use the same MSA where you are living at right now to file the H-1B?
Yes.
Okay, doesn't matter. The headquarters is in the Mars or is in the moon. It doesn't matter. We don't recognize the cyberspace as you think so. We only recognize your butt. Where is your butt sitting? Your butt was supposed to sit in, let's say, New York MSA, and now your butt is still sitting in the New York MSA. That's all we recognize. Whether you log into the cyberspace that is in California, we don't consider that. So you are safe. We don't see any reason why you need to file an amendment.
Okay. And follow-up question is like, yes, my salary remains same compared to the previous petition, but the level got degraded. So still, does it cause any issue?
Let me ask you this question though. What about the LCA wages? Are they going to pay lesser than the LCA wages?
No, it is going to be same as my previous LCA.
So how do you know that? How you're telling that the job description, title, everything remained the same. Now you're telling that the level has fallen down. Why there is a discrepancy in what you said before and what you're telling me right now?
It is because of recent change in wage levels.
Well, forget about wage levels. You already got the approval in the old wage levels, right? Now, your job description, your title, everything remain the same.
Okay.
So you're good. I don't see any, you don't have to go into the new law and search where your wage level falls into. It doesn't matter. Right now, you belong to the old law.
Okay, got it.
Okay then, thank you.
Because my attorney was saying since there is a client change, it is considered as a material change, even though I was working on the same MSA. So they were asking for an amendment.
Client change is not, MSA change is the one that need to be considered, not the client change. You sent the same job title, same job description, and same MSA. So you don't need, even if the client changes, it doesn't matter.
Okay, got it.
Okay then. Thank you.
Thanks a lot, Rahul.
Thank you so much. We have the next caller here, Rahul 4224. And antakante mundu YouTube question teeskundam. YouTube question is from Deep K. Applied 485 on October 26th. Can I travel outside the country without receiving 485 receipt? Will it affect my application in any way? I understand I-131 AP will be cancelled and that needs to be reapplied.
I wouldn't recommend it to travel without the receipt notice, but is it illegal to travel without the receipt notice? No, it's not. They can travel. He's right in saying that he should not rely on the I-131. Even if they approve it, he should tear it down. He should not use that I-131 approval. But as far as the EAD is concerned, he can use it. I-131, he should not be using it. Technically speaking of, yes, he can go outside the country, assuming that he's trying to come back on H1 or H4 or L1, L2. I'm not expecting much problem for him in coming back.
Okay. Nice, Andy. So we have the caller 4224 waiting. Please ask your question here. We can hear you, sir.
Hello, Rahul.
Yes, sir.
Can you hear me?
Yes, we can.
ఇందాక అడిగిన దానికి ఫాలో అప్ క్వశ్చన్ అండి, లైక్ అదే కెనడా గురించి అడిగాను కదండి. సో ఇప్పుడు నా క్వశ్చన్ ఏంటంటేనండి, లైక్ ఇప్పుడు నెక్స్ట్ ఇయర్ ఒకవేళ నా ప్రయారిటీ డేట్ కరెంట్ అయిపోయింది అనుకోండి, దెన్ ఎన్ని ఇయర్స్ నేను వెయిట్ చేయొచ్చండి? లైక్ అలా కరెంట్ అయిన తర్వాత కొంతమంది 1 year తర్వాత ఫైల్ చేయకపోతే అది ఇంకా యూజ్ చేయడానికి అవ్వదు అంటున్నారు.
So practically, if the priority date has become current and then you don't use it, when you're saying priority date current, it has to be current in the final action date, not the filing date, though.
Yes.
So there is a deadline.
So I don't have a plan to come come back until 4 years. So if it becomes current this year, for example, I cannot come back in like 4 years.
What is your priority date?
2016 EB3.
Very unlikely for it to be current in the next 3 to 4 years for the final, because right now it is only 2010. It hasn't moved to 2015. It is only the filing dates that have moved, not the final action date. So if I were you, okay, I will take the chance of going to Canada and staying there for 4 years and coming back without much worrying about these dates becoming current. Having said though, there are some small element of risk in what I'm telling you, but if I were you, I would go there and stay there for 4 years and come back.
Okay. I have one more question, sir. Like my wife is in H1 and I have a I-140 approved. So I'm trying to move her to H4 EAD. And she still has 1 year H1 left on her current H1. So I'm trying to file her H4.
Yes.
But if she gets another job, can she use that? Because it might take like 10 months for her to get approval for H4. Can she file, if other company comes, she can file the H1 transfer?
While the H4 and EAD is pending?
Yes.
Would she be stopped working for the company once you file the H4 plus EAD, or would she continue working for the previous company for which she has the H1B approval?
She will continue to work.
Absolutely no problem in having company B file a H1B transfer application while the H4 application is going. If she is continuing working with the company that has a H1B, no problem in having the new company filing a H1 transfer.
Okay. But if she stops working, then it might be a problem.
Right. If she stops working, she has a 60-day grace period and the I-94 should still be valid. That becomes, after 60 days, it becomes a problem. If she continues, no problem whatsoever at all.
Thank you very much, sir. Thank you.
Thank you so much, Randy. Let's take the next caller here. The caller ends with 7950. We have a lot of callers waiting here. And before that, we also take a YouTube question. And it is from Sunu Reddy here. He says, my priority date is September 2011. I have filed downgrade concurrent petition last month as new I-140. My concern is my employer moved location A to B in 2016. The new location also is in same state and same MSA. Do you see any issues on filing concurrent petitions?
Because your company has changed from A to B and because of the MSA location within the same MSA, I do not see any problem whatsoever at all because of the address change.
Okay.
Because it's in the same MSA.
Okay, that's good to know. So we have the next caller here, 7950. Please unmute yourself and ask your question. Please press *6 to unmute yourself and ask your question, Andy. Yes, we can.
Hi, 𝗧𝗔𝗟𝗪 and Rahul there for taking my call. So I have my form filed and I-140 approved with a Indian MNC in EB2 category in January 12, 2015. I moved to a different company, small scale company or a startup company. Do you think it will be any problem if I file POM and I-140 with my new company?
If you're employed with the company and they're paying you a salary though, I'm not expecting much problems for you to get a labor and I-140 approval with a startup company. When you say startup, how big is this company? How many employees?
We have only 50.
50 is a big company. I don't know what range that you use. It's a huge company for me. I don't see any problem with it. 50 is a big company.
Okay. Okay, Rahul. Thank you. Okay. My follow-up question is, I have done my BTech from electrical and electronic engineering, and after my PERM approval, I did my master's in computer science from BITS Pilani as a work integrated program. With the new changes happening with the specialty occupation, do you think there will be any issue in my future I-140s?
No, you have a master's degree from BITS Pilani, which is considered to be a recognized university or recognized institution. I'm not expecting much problem for you. Either H-1Bs or I-140s.
Thank you.
Thank you.
Thank you so much.
Thank you.
Yeah, thank you. We have the next caller here, 55353. Before we admit him and take his call, let's take the video question. The question is from Viren. Can we have you on mute, sir? 535. Can you? Probably we can take the call here, Andy. Please. Caller ending with 5353. We can hear you. Please ask your question.
Yeah, hi. Can you hear me?
Yes, sir.
Yes.
Hi, Rahul. My name is Mahesh. So my current employer, we applied, I think including me, we have applied a couple of labors to the Department of Labor, and we got rejections. And when I talked to my HR, they said we have some technical glitch on the DOL website, so we resubmitted for consideration. And the consideration
was it denied after 5 months? So was it denied after 5 months? Is that right?
Yeah. Yes. Yeah. It's denied after 5 months. Yes, sir.
Yeah. If it's denied after 5 months, yeah. So they sent it for reconsideration. It's been denied. Okay. So what questions do you have right now?
So do you hear these technical glitches recently? I know there is one in 2015.
There was one in 2010, I remember it. But I don't know what technical glitches they are speaking about. You have to be, they have to be very, I want to see the denial to see what's the issue it is.
Do we have any other options right now, to submit for another reconsideration because it's a technical glitch? Or
as I said to you, I need to look into the denial though. If it is improperly denied, you can go to federal court and get those things reversed. But if it's properly denied, there is not much we can do about it. And you're not telling what the technical glitch is. When they deny the labor certification, they'll give a specific reason. Here is the reason why we are denying the application. And I want to know the reason. You're just telling technical. So there is something your company is hiding from you. I want to see the denial to evaluate and tell what are your probabilities. Okay.
They didn't give the reason, final reason why, right? But I'll try to get it and maybe next week.
That's important. Yeah. That is important why it has been denied.
Got it, sir.
Okay.
Yeah. Thank you.
Thank you.
Thank you so much. And here we have the next caller. The caller ends with 9396. Before we take the caller's question, and we have a YouTube question from Viren. If I have an EB3 EAD and my wife an EB2 EAD, both current in October 2020 filing dates, and both use our own EADs after 180 days, what are we married to? Okay, EB2 or EB3? How do we keep both? With
you both are getting married to your respective 485 applications if you start using the EADs.
Okay. How to keep both without staying on non-immigrant visa?
How to keep what?
How to keep both without staying on non-immigrant visa?
Well, once you use the EAD, you are married to your 485 application. So now you're relying on the 485 application. So you're married to the 485 application. That's it. You'll have to wait for the 485 to be approved.
Okay. Perfect. So let's take the caller here. Caller ending with 9396. We can hear you, sir. Go ahead. Please go ahead. Caller ending with 9396. Please go ahead with your question. We see you're on unmute. If you are on mute, please press *6 to unmute yourself. Before we get the caller, I do not see him. Can you please press *6 to unmute yourself? Rahul Garu will take a question here from YouTube in the meantime. It is from Pinnacle Power. Can we get H1 extension for 3 years while I-485 processing going on, or every year H1 needs to be renewed as we just, as well, just like the EAD AP card?
Since the priority date for the final action date is not current for you though, I don't see a reason why the immigration has to approve you only for 1 year. I would go for 3 years application, 3-year approval. The technically, if the final action date is current and the 485 is still pending though, they can, you're only allowed for 1 year extension. But since your final action date is not current, I would argue that you should get the 3 years H1B extension. And I have not seen much problem in getting a 3 years H1B extension when the final action date is not current.
Okay. Okay. Thank you so much, Andy. I think we have the caller still. I can see him. Please press *6 to unmute, or you may have to unmute your phone if you're muted on your phone. Please press *6 otherwise.
Hi, can you hear me?
Yes, go ahead, ma'am.
Oh, sorry. Hey, Rahul, thank you. So,
You have to speak a little bit louder.
Oh, okay. Can you hear me well now?
Better now.
Okay. Okay. My priority date is December 9, 2011. So we filed in EB2, basically. Now we filed a downgrade with a new application of 140. My question is, in case
wait, I'm confused.
EAD,
You said you filed under EB2 directly. Is that right?
No, EB3 concurrent filing and the 140 downgrade to the EB3.
What was your priority date?
December 9th, 2011. Initially filed under EB2, so it is not current, so we have to file.
I got it. Okay, got it. Keep going.
Sure. My husband is a derivative on my application, even though he has EB3 in 2013. So, however, in case if you use the EAD now, because I'm the primary applicant, so in case the EB2 becomes current, final action, I'm talking about the final action in future. So can we switch to the whatever that called interfiling or whatever, the same 485 application as being primary?
You can try to switch to the EB2 application because your I-140 was still there at the time. You can switch it though. I don't see any problem in it.
Okay, even though we use the EAD in EB3, whatever.
Right. It's the same underlying 485 application. So you are getting married to this 485 application. Your I-140 was previously approved. You can try to switch it. You can try to switch it under interfiling.
Okay, thank you. That is helpful. Another question I had is on the educational basis, because I hold an MBA. So will there be any problem in downgrading 140 in the current situation?
What does the position require? If the position in the labor certification requires MBA, I don't see any problem. If the position doesn't require an MBA, it requires, let's say, engineering, and you don't have engineering, you have only MBA, that becomes a problem.
Okay. I think initially they filed, I think they used the MBA itself. I don't know. I mean,
you can look into the labor certification application, determine what is the qualification required for the position though. But without looking at it, it's going to be very hard for me to comment on.
Okay, I can probably check on that. Thank you. That's helpful.
Sure.
Thank you so
Thank
much.
you very much for tuning
in. Rahul Garu probably will take the last caller on the show, Andy. The caller is with 4954. Before the caller's question, let's take a YouTube question here. It is from 𝗧𝗔𝗟𝗞 𝗦𝗪𝗧𝗛. I have my stamped H1B visa till February 2022. I also applied for my 485 and I-140 downgrade as my priority date is July 2014. So while this process is going on, can I travel to India? Will this affect my I-485 process?
You can travel to India. I don't see any problem. But the only thing is that your I-131 will be denied. If it's not denied, even if they approve the advance parole, I do not want you to use that advance parole for any purposes though. Yeah, you can, since your stamping is still valid until 2022, you can go and come back. Your EAD will still be approved, but the advance parole should be denied, will be denied. If it's not denied, I don't want you to rely on that advance parole.
Okay, thank you so much. And we have the caller here, 4954. Please ask your question.
Hi, hello, can you hear me?
Yes, sir.
Yes, absolutely. We can.
Yeah, my name is Anand. I have a complex question. My wife went to India on February, and actually we had a visa approval until 2021. But while she came back, and the port of entry officers stamped her I-94 as the April 2020. And because of COVID, we couldn't renew because SFO office was closed. Then we had an issue with getting the passport, and we received the passport on June. And there is a 3 months of delay in filing I-539. What's the possibility? I filed it again with my new employer because I lost my job on July. Then I filed with a new employer. But what is the other option? Now it's still pending. With mine is approved. Yeah, my wife's is still pending.
I don't know why you had to file the extension after April, though. If your passport was still
because
pending,
I changed in employer.
Yeah, but you still have a H-1B approval for a 2021. You could. When did you change the employer? You changed after April or before April?
This 2020 June.
But you could have filed for your wife's H-4 in March of 2020. She came in February. So she definitely is not in legal status. I would rather want her to leave the country and apply for the H-4 visa outside the country. Because if the H-4 gets denied, it's going to have a lot of negative consequences. There is a good possibility that the H-4 might be denied because she filed it after the I-94 expired.
But one good news we received last week, she got a fingerprinting request and we did that fingerprinting.
That doesn't mean anything. They haven't even opened your file yet. Fingerprinting is an automatic process. It doesn't involve an officer to open it, to take a look into it, to see, to determine whether this H4 is approvable or not. It's an automatic process. You paid the $85, that goes into a different account, and then you get the fingerprint notice. So no, do not rely on that.
So you recommend to go outside, to go to India and come back?
That's right. That is a safer way. Okay? Don't risk too much.
Okay, thank you, sir.
Okay.
I have one more question, sir. Sorry if you can answer. Because I changed my employer, my previous employer, my PD was on 2013, and my previous employer was ready to downgrade from EB2 to EB3. And I'm going ahead with them. Is there any issue with that? Because my previous employer is a very good company, and they have.
I'm not worried for you that should be much of a problem for you going back to the employer, but I'm worried for your wife that she should still leave the country and come back. So you may have to go alone in filing the 485 application.
Okay. And another question, continue with this. My new employer is ready to file the green card. Should I go ahead with them, or I rely on the previous employer, I-45?
There's nothing wrong to have an extra safety to have a new employer to file for a label certification. Nothing wrong with it.
Yeah. Thank you very much, sir.
Okay.
Thank you.
Thank you. Thank you. Thank you very much.
Thank you, Sita. And
thank you.
So much. Thank you so much, Rahul Garu. That was the last caller that we had. There are so many YouTube questions. We have a lot of callers waiting, but probably you have any more questions, please reach out to Rahul Garu's office directly, or you can as well wait for the show next time, same time. And it's going to be next week, every Sunday at 4 p.m. Eastern. And please do subscribe on TVASIA Telugu on YouTube, Twitter channels as well. Thank you so much. Thank you so
Thank you
much.
very much. Thank you, Sita. Thank you, everybody.
ఈ పండుగ సమయంలో అందరూ గెలుస్తారు మలబార్ గోల్డ్ అండ్ డైమండ్స్ లో. గోల్డ్ లేదా డైమండ్ ఆభరణాల కొనుగోలుపై గోల్డ్ కాయిన్స్ ఖచ్చితంగా గెలుపొందండి. పైగా 10% అడ్వాన్స్ చెల్లించి గోల్డ్ రేట్ల పెరుగుదల నుంచి రక్షణ పొందండి. బంగారం ఎక్స్చేంజ్ మీద 0 డిడక్షన్ ఆనందంగా అందుకోండి. 10 దేశాల్లో 250 స్టోర్లలో బెస్ట్ డిజైన్లని బెస్ట్ ధరాల్లో పొంది గ్యారంటీడ్ గోల్డ్ విన్నర్ అవ్వండి. కేవలం మలబార్ గోల్డ్ అండ్ డైమండ్స్ లో మాత్రమే. మలబార్ గోల్డ్ అండ్ డైమండ్స్, celebrate the beauty of life. ఈ పండుగ సమయంలో